Welcome to the Cannabis Compliance Updates for September 2022 in the Midwest region. In Illinois, we have an advisory update for management services agreements. So on August 2022, the update since originally publishing the FAQs, the department has received many questions regarding the conditional license process and potential challenges new conditional licenses may face related to the management services agreements, MSAs. Historically, the department has interpreted MSAs as requiring the managing entity and its managing member to register as principal officers of the underlying licenses. To offer conditional licensees an opportunity to enter into an MSA during the conditional phase, the department may accept a modified version of an MSA referred to as a conditional management service agreement, acronym CMSAs, under certain conditions which are further explained on page 4. So here's from page 4. So are management service agreements allowed during the conditional phase? No, management service agreements require new principal officers to be added to the ownership structure, and because conditional licenses may not be sold, transferred, or assigned, MSAs may not be entered into during the conditional phase. So update: traditional MSAs remain prohibited during the conditional phase. However, the department will consider a MSA to be part of a licensee's ownership or control such that the conditional managing entity, CME, agents or members must register as principal officers of the licensee if the following conditions are met. The department may consider such agreements during the conditional phase to be conditional management service agreements. The CMSA contains explicit provision stating that the agreement is temporary and terminates upon the conditional license receiving an AUDO license. The CMSA contains an explicit provision that the CME will exert no ownership or control over the conditional license or corresponding AUDO license, nor have any provisions granting CME an ownership interest in conditional license prior to, during, or as a result of the managing service rendering to the conditional license. The CMSA may cover handling of day-to-day operations as well as hiring of subcontractors or other managerial functions, but ultimately corporate control and decision-making must remain with the conditional license. The CMSA does not include any provisions granting CME any rights of exclusivity should conditional license obtain an AUDO license. The CMSA identifies flat fees as the form of payment. The CMSA does not take effect until approved by the department. The CMSA cannot be assigned, transferred, sold, or any combination thereof. The CMA, once entered into, cannot be changed, modified, or amended during the conditional phase. The department or either party can nullify or refuse to approve the CMSA deemed to be coercive or otherwise objectionable to the stated purposes of the CRTA. For this reason, the department strongly recommends that both parties to the CMSA be represented by separate attorneys licensed in the jurisdiction where the agreement is negotiated and agreed upon. All right. Another one out of Illinois. Illinois regulators barred investment into conditional licenses, drawing a lawsuit from license holders. According to Illinois regulators, conditional dispensary license holders are not only barred from selling their licenses until full operation, but they are also barred from taking on outside equity investment and from signing management service agreements, which we just talked about, MSAs. This week, a pair of attorneys who are also dispensary license holders filed suit against the state, charging that the state's ban on equity sales is unconstitutional and violates existing state law. The state's ban has obstructed social equity conditional license holders from successfully operating their companies, from considering and or accepting purchase offers, from raising capital through investors, and from entering into MSAs or other strategic partnership agreements to become operational, says the motion for the preliminary injunction filed by WAH Group and Hay in Cook County Circuit Court earlier this week. All right, shifting on over to Michigan. So just letting you guys know about some disciplinary situations, these fines that are happening. They're withdrawing formal complaint. A lot of like $10,000 fines. And you can find like why they got these at CRA. I actually did not pull this information, but just showing you what's happening in Michigan and who's getting fined, because I like to say Michigan is known for the state that likes to kill businesses with 1,000 cuts. So that's something that's always happening there. All right, another update out of Michigan from ProCanna, marijuana-infused edible products packaging. So the CRA has updated its previous guidance issued on marijuana-infused edible products packaging to include guidance for marijuana-infused non-edible product packaging. The previous bulletin provided for a period of education regarding marijuana-infused edible products before the CRA began taking enforcement actions. The CRA has become aware that many licenses do not understand the requirements of R420.403 subsection 7 in the marijuana-infused products and edible marijuana product rule set also applies to marijuana-infused non-edibles. Due to the extent of the non-compliance, the CRA has determined that licenses require additional education regarding the requirement for marijuana-infused non-edibles before taking enforcement action against licensees. The CRA Enforcement Division's field operations teams will educate marijuana businesses regarding the updated guidance for marijuana-infused non-edible products, and effective March 1st, 2023, will begin conducting investigations when necessary for non-compliant marijuana-infused non-edible product packaging. It is important to note that the March 1st, 2023 effective date for the CRA to take enforcement action only applies to marijuana-infused non-edibles. The CRA has and will continue to take enforcement action as necessary for marijuana-infused edibles that are not compliant with rule set 420.403 subsection 7 in the marijuana-infused products and edibles marijuana products rule set. The update guidance stock has also been saved in ProCanna. Another one out of Michigan. Governor Whitmore appoints acting executive director to Cannabis Regulatory Agency. So Governor Gretchen Whitmore announced the appointment of Brian Hanna, an acting executive director to the Cannabis Regulatory Agency, CRA. Effective September 19th, Hanna will join the CRA, bringing extensive experience to fill this vital role with the Whitmore administration. Hanna's previous service in the Marijuana Regulatory Agency, now CRA, under former Executive Director Andrew Bisbrough, will ensure he continues the mission and ongoing work of the agency. Hanna spent 5 years with the CRA as the manager of field operations, inspections, and investigations. He has a law enforcement and military background, having previously worked as criminal intelligence manager and analysis with MSP as a deputy sheriff for Kalamazoo County. He also served as a captain in the United States Army Reserve with a combat deployment to Afghanistan from 2022 to 2021. Hanna holds a Bachelor of Arts in Criminal Justice from Western Michigan University and an associate's degree in the law enforcement from Kalamazoo Valley Community College. The state of Michigan will conduct a nationwide search to select a permanent executive director for the CRA. In February, Governor Whitmore signed an executive order consolidating the regulation of the processing, distribution, and sale of cannabis and hemp into a single state agency. The Cannabis Regulatory Agency, CRA, established April 13, 2022. The CRA replaced the Marijuana Regulatory Agency, MRA. The CRA has authority over Michigan's cannabis and hemp processors, handlers, and distributors, and is housed with the Michigan Department of Licensing and Regulatory Affairs, LARA. All right, we got another one out of Michigan. Required testing for mycotoxins. So the Cannabis Regulatory Agency is reminding licensees the requirement that all marijuana products, including flower, which fail testing for aspergillus, must subsequently be tested by mycotoxins. Rule 42306, subsection 3, promulgated on March 7, 2022, states products that fail testing for aspergillus may be remediated after subsequent testing for mycotoxins in accordance with Rule Set 420.305, subsection 3H. Testing for mycotoxins on a product which has failed for aspergillus should be conducted prior to submitting a request for remediation to the CRA. CRA states that to ensure mycotoxin testing is performed prior to approving remediation requests, and licensees' remediation requests will be denied if the test has not been completed. As is customary with newly implemented testing requirements, the CRA is allowing licensees time to educate on the requirements and come into compliance prior to enforcement, which will begin on December 1st, 2022. So for that one, definitely like create a checklist and like some sort of alert system, like if your test batch fails, like how to handle that. That's pretty critically important, I feel. And then just another one out of Michigan, super simple. The Cannabis Regulatory, the CRA has added the following resources under tips for licenses, tips for renewing applications, and just miscellaneous forms. Just letting you know. All right, 2 more updates. Missouri judge blocks attempt to kick legalization off ballot. On September 9th, opponents for Missouri's adult use cannabis initiative suffered a major setback when a state judge rejected their lawsuit to remove the measure from the November ballot. The lawsuit, led by an anti-drug activist named Joy Sweeney, with support from the Protect Our Kids Pact, made claims regarding both the initiative itself and the state's process of counting and validating the signatures gathered earlier this year to place it on a ballot. They claim that the initiative, which is set prior on the ballot on Amendment 3, violates a requirement that ballot measures only cover a single subject. Prohibitionists have successfully used this argument to kill legalization measures in South Dakota and Nebraska. The lawsuit also accused Missouri Secretary of State Jay Ashcroft of improperly validating signatures gathered in favor of the campaign. In his ruling, Cole County Judge Cotton Walker dismissed both accusations. Walker further ruled that Sweeney did not have sufficient evidence to prove that she actually resides in Missouri and thus did not have legal standing to plead her case. Sweeney's legal team immediately filed an appeal to the ruling. For one, they claim that they have evidence that Sweeney is in fact a Missouri resident. Missouri officials must take a final decision by Tuesday, September 13th. Okay, and then one really quick one just out of Ohio. Revisions and additions to OAC Chapter 3796, effective September 5th. So a list of things happening. But here's all of the different things that are getting updated in the administrative code for Ohio. Things like dispensary access, compliance and inspections, discipline, suspension, failure to properly store medical cannabis, fee structure, caregivers, duty to report, more discipline, suspension for patient or caregiver, confidentiality, release of registration patient information maintained by the State Board of Pharmacy, suspension of access in the patient information, establishment of additional forms, assignments of the product identifier and product identifier fee. So awesome. And there are your cannabis compliance updates for the Midwestern region in September 2022.